that the government could prorogue Parliament whenever it liked for as long as it liked. And we rejected that argument effectively as reversing the result of our 17th century history. The question what you then did in relation to the prorogation had not been addressed by the parties. Now, neither of them had presented argument on the point. We raised it towards the end of the hearing. What should we do? And we received, at the time, very perfunctory submissions because nobody had really thought about it. And afterwards, we had a more detailed submission. We had more detailed submissions in writing, and we reached the conclusion, as a matter of law, that we did, that you find in the judgment, and I appreciate that the committee includes a number of qualified lawyers, including Lord Howard, and if you disagree with it, obviously you're entitled to disagree with it, but that was our decision.
But it's the explanation that I'm searching for, because I mean I have the relevant part of the judgment here, and
well, you have the advantage of me.
It was dealt with. Well, I really have. It was dealt with in two sentences by Lady Hale. She acknowledges the prorogation itself takes place in the House of Lords and in the presence of members of both houses, but it cannot sensibly be described as a proceeding in Parliament. It's not a decision of either House of Parliament. Well, that's an assertion. It's not an explanation of why it can't sensibly be described as a proceeding in Parliament, when I think most people, on a pretty ordinary construction of the language of Article 9, would indeed have regarded it as a proceeding in Parliament.
It was, if I may add, it was a closing down of Parliament. It was the announcement of an outcome to Parliament. And I think one has to remember that the Bill of Rights was a provision designed to protect Parliament from the executive, and in those days from the courts, which had historically been the instrument of government. In the late 17th century, I think out of the 12 High Court judges that there then were, in the reign of Charles II, he dismissed 11, and James I and seventh dismissed 12 in the 3 years that he was king. So the Bill of Rights, I think, has to be seen in its historic context and its purpose. And its purpose was to protect Parliament, not to allow the executive to remove Parliament sitting. And I think that's a factor in the thinking behind the interpretation of the Bill of Rights.
Article 9, in its terms, clearly protects Parliament from the courts, but there we are. Can I put another point to you on the case? The basis of the decision was that prorogation had the effect of preventing Parliament from carrying out its constitutional functions. But of course, Parliament had ample opportunity to reverse the prorogation, something that wasn't even mentioned by the court in its judgment. As Professor Timothy Endicott has pointed out in his masterly article in the Law Quarterly Review, between the 3rd and the 6th of September 2019, the two Houses of Parliament suspended their ordinary timetables and approved a bill to require the Prime Minister to request an extension of the Brexit deadline if he didn't secure Commons' approval for withdrawal. And Parliament could very easily have provided in that legislation that the prorogation should not take effect, as it actually had done to make prorogation during October functionally impossible in Northern Ireland legislation. So we have a situation in which Parliament chose not to block the prorogation, but the Supreme Court decides that it should have done.
I don't recall that point being put to us. I think the argument was made that Parliament could have passed a vote of no confidence in the government and brought down the government. I remember that argument being made. But as I say, we were faced with an argument of essentially, well, a sort of argument that might have appealed to Charles I or James II, and that, as I say, Parliament sits at the pleasure of the Crown, and the government, effectively as a successor of the monarch in effectively exercising the powers of the Crown, can dismiss Parliament whenever it pleases for as long as it likes, and that's an argument we weren't prepared to accept. I should say, if I may, the rules of engagement of these appearances aren't really intended for us to be quizzed on the reasoning of our judgments.
Well, you will appreciate that the opportunities for the Supreme Court justices to be in any way accountable are very limited.
Well, we're not accountable for our judgments to any institution.
Two other lords. Lord Hope, was your point very quick?
Well, I took part in the prorogation ceremony, and it was the first time I've been told by a court that what I was doing was illegal. Yes. So, I do wonder, and this is, I don't know whether you would like to comment on this, whether you would have taken the same view if you'd been members of the House sitting in the appellate committee and being familiar with what actually happened. I don't know whether you really knew what the prorogation amounted to and what was actually done. I mean, that's purely an observation. We can't go back into the...
Yes, well, that's an interesting observation. The only member of the court who was a member of... Well, we had two members, I think, who were peers at that time, Lady Hale and Lord Kerr.
Yes. I don't know whether they've ever seen the prorogation.
No, no, and I certainly haven't.
I think it may be that something was lost there. Thank you.
Thank you. Lord Howell and then Lord Faulkner.
Yes, good morning. Can I move to a slightly less contentious area? Not only slightly, though, because I wonder whether during the time of lockdown and the pandemic, one of the problems for the judiciary generally in the courts and your court in particular was sort of interpreting what Parliament's will really was, in particular over difference between law and guidance. That must have been a problem. And if I can add a specific case just to strengthen this question, there was a case before the courts about 2 years ago, in which the detainees, former detainees in Northern Ireland, brought a case complaining that their detention orders had been signed by junior ministers instead of Secretary of State, and your predecessor, Lord Kerr, ruled that they had a case and ruled in their favour. This has seemed to us something did go off the rails here, because the actual detention of the terrorist order 1972, which I had a hand in taking through the Commons, was universally agreed with a specific clause in it that junior ministers would be allowed to sign these interim contention orders, custody orders. But Lord Kerr seemed to argue that because the Carl Toner principle of non-secretaries of state signing wasn't specifically in the order, therefore the Parliament's intention was not really to delegate these issues at all to the and he ruled that only the Secretary of State should sign. That seemed to us a real puzzle, a real clash between Supreme Court and the obvious, perfectly obvious will of Parliament. I don't ask for your specific comment now, but is that not an example of where things went wrong?
Well, I remember actually this question being asked when we appeared last year, and I think I may give a similar answer. The view, the court, as you say, it was presided over by Lord Kerr. It included the Lord Chief Justice of England and Wales, and the decision they came to was a unanimous decision. Now, I didn't take part in it myself. I understand that it's a controversial decision, legally as well as perhaps politically. And it's always open for any party, including in this case it would be the government, who wants to test the correctness of a case to raise the point again. The Carl Toner principle is one which obviously pervades government, and there may be, sooner or later, there will be another case in which somebody relies on the Adams decision, and there will be scope then, if anybody wishes to challenge the correctness of Adams, for us to reconsider it.
Is it something to do with the fact that the court, in these kind of situations, doesn't take evidence? I mean, there were people to be called, but nobody was called. Is that the way? As a layman, it's quite hard to discover.
Yes, certainly our court doesn't take evidence. If there was an issue about parliamentary intention, council do place before us such materials as there are. For example, parliamentary debates, white papers and the like are routinely referred to in court. So there is scope for us to consider that kind of evidence.
Yes. But I think obviously many of us would have sympathy with the point that finding out what the will of Parliament is getting more difficult these days. So I think we'd be on the side of the judiciary in understanding the growing difficulties.
Well, I'm pleased to hear that. What we're trying to do is to encourage people to pay more attention to what Parliament has actually said, and less attention to what the government may have said in prior consultation papers and the like.
Thank you. I'm conscious of the time, and there's lots of questions. I'm going to call in Lord Faulkner, and then, Lord Faulkner, I'm going to ask you to lead us into question 4 after that.
Can I just put a marker down? Listening to Michael, who is the most formidable advocate, I do think it's wrong that we should be prodding away at a decision that's been made, because for better or for worse, the Supreme Court have got to make these decisions, and they're not here to be told they're wrong or give reasons beyond that in the judgment. And David was doing a bit the same there. And it will, I suspect, lead to problems if we allow that to go on. So I just put a marker down that's wrong. Could I raise a broader question? There's no doubt there has been much greater criticism of the judiciary in a political sense since Brexit. Enemies of the people, etc. Has that affected the Supreme Court? Do they think they've got to improve their relationship with the executive? If so, what have they done about it?
Yes. Well, yes, it does. I think it's affected us in 2 ways. One is we are trying to explain more fully in our judgments.
Not fully enough, as far as Lord Howard is concerned.
Yeah, we are trying to explain more fully in our judgments how the approach we're adopting is based in an understanding of our constitutional role. But at another level, we're doing an enormous amount to try to engage with Parliament and with the government in order to build a stronger relationship in which our role is better understood. I do have a note here of a whole list of things I was going to say about that, if you just give me a moment. Yes. Well, I've been holding meetings with the Speaker of the House of Commons and the Lord Speaker of the House of Lords to consider how best to engage with Parliament. One of the Speaker's suggestions was...
My question is much more focused on the executive. I don't think your problem is really with Parliament.
Right,
and there are tensions always between the executive and the judges. They're worse at the moment than they've ever been, is my feeling.
Well, I don't have that view. I was concerned about the relationship when I took over the presidency, because it was obvious that following Miller II, there had been a drop in the temperature, to say the least. But I've had a good relationship with each Lord Chancellor we've had during my presidency, and it's very clear to me that the current Lord Chancellor has no concerns about our failing to understand what our constitutional role is. And as I've explained, in relation to the taking forward of a review of administrative law, which began with Lord Fawkes's report, and also in relation to the taking forward of reform of the Human Rights Act following Sir Peter Gross's report, we have been able to engage successfully with the Ministry of Justice through justices discussing operational matters with officials, continuing something that in fact had begun. I mean, that sort of engagement, the first I was aware of it was during Brexit, when we were able to engage with officials over some of the legal implications of Brexit and how they might affect the courts. As I say, we've taken that's now become an accepted way of working wherever there are issues on which the court could productively cooperate with the government within our proper constitutional role.
If I may add, Lord Faulkner, as well as the work which Lord Reid describes of engaging with the government departments, I have sought to address what I think is a mistaken belief that the Supreme Court has departed from principle and become more activist than its predecessor, the House of Lords. And in the course of last summer, I gave a series of lectures on the extrajudicially on the judicial development of public law and the limits of the judicial role, which sought to place the developments of constitutional and public law in their historical context, identifying circumstances, including parliamentary initiatives, which have enhanced the judicial role, and also identifying the necessary limitations on that role. And I published an amalgam of those lectures on the court website and in the Journal of Judicial Review. So we have sought to address this perception by the executive and supporters of the executive that somehow the court has become more activist. It is not something that Lord Reid or I would accept as a correct characterisation.
I should add that in the nature of things, the government department we engage with the most is the Ministry of Justice, and the minister with whom I engage the most is the Lord Chancellor. But we have also developed a successful engagement with the Foreign Office in relation to our international activities and how they can work collaboratively with activities undertaken by the Foreign Office. They're bringing people to us as part of their induction, effectively, before they're sent out as ambassadors, is partly a reflection of that. But we're also, if for example, if I'm meeting the Chief Justice of Kazakhstan and the Kazakhstan ambassador, then I get a briefing beforehand from the Foreign Office on their take on the situation and any key messages they want me. For example, I had a meeting with Prime Minister Modi in India just immediately before the lockdown, and I was given a tremendously good briefing by the Foreign Office beforehand, and the embassy was able to make quite a bit of my visit and the engagement with the Indian Supreme Court that I was involved in.
Thank you.
Yes.
Good.
I'm not going to ask you about cases that I should have won, but lost in front of you. I wanted to ask you
lost.
Yes, I lost. About the relationship with the Lord Chancellor, and I think you've already told us about that. As you may know, this committee is doing an inquiry into the position of the Lord Chancellor and the law officers in particular. And you may or may not want to comment on that. But there's just one particular thing I'd like to ask you, if I may. The Lord Chancellor has, of course, a very important function of protecting the independence of the judiciary. But the Lord Chancellor is also the Secretary of State for Justice and has a big delivery department, including prisons. And also, we see from our research that the Lord Chancellor, or rather the Ministry of Justice, is the biggest receiver, as it were, of incoming judicial review applications. Mm-hmm. Now, what do you think about the apparent tension there between a Lord Chancellor whose position is, amongst others, and fundamentally important to protect the independence of the judiciary, and yet at the same time, he, as the voice in Cabinet, is having to explain the fact that his department is receiving a large number of applications for judicial review. I hasten to add, I don't think these get to court all the time, but at the very least the preliminary steps, I understand, are taken.
Yes, yes. Well, I'm afraid I don't deal really with Lord Chancellor as a departmental operational minister, because the Supreme Court falls outside the courts to which he's responsible, and obviously I'm not involved in the prisons. The Lord Chief Justice would deal with him on an almost daily basis, I should think, in relation to operational matters in the courts. I deal with him. I deal with him really in relation, as I say, to matters of policy. In relation to his statutory role is not simply to defend the independence of the judiciary; it's to defend the rule of law. Yeah. And that I think is a very important role, because we are not at home we the judges are not at home in the fields of politics or government or the media, and we would be hopelessly outgunned if we ever tried to enter those fields. And so having a senior government minister with that responsibility is very valuable. As I say, I don't see it in relation to, I don't have experience of it in relation to his own departmental responsibilities, but I do see him as having an important role in defending the rule of law in relation to other ministers, as a voice who speaks up for it in cabinet. If other ministers are perhaps not as aware as they might be of something like judicial independence, he has an important role to play, and he also does, or may have, in public debate. Although, frankly, it's more the internal debate in government that I'm more concerned about.
Would you regard it as inconsistent with his duties to, for example, promote legislation which changed the basis of judicial review? I'm talking hypothetically rather than the rather modest bill that's in fact before. Yeah. Would you consider there any conflict there?
I think it may be more of a theoretical conflict than a real one. For example, if he were to propose measures, as a departmental minister, if he were to propose measures in relation to judicial review which effectively jeopardise the rule of law, then I and no doubt other senior judges would try to prevail on him to do otherwise, and we would tell him that it was inconsistent with his responsibility to uphold the rule of law. If we can't persuade him in his present role, I'm not sure we would do better at persuading him if his role were distinct from the departmental role in relation to the courts. Yeah.
Okay. Do you want to come in briefly on this? I'm running short
well,
of time.
I want to come a slightly different angle to the same question.
Okay, but could you keep it brief?
Yeah, I will try and be brief. Just that I was particularly pleased by your comments last year, Lord Reid, about international law, because you said that the fact the government may propose legislation and Parliament enact legislation that's in breach of international law is of no significance to your role in applying the Act of Parliament. And you further said that in the case of the very controversial Withdrawal Act and the Northern Ireland Protocol, although if Parliament's given effect to one statute and then later it qualifies that effect, in that situation the constitutional rule is that the later statute prevails over the earlier one. I mean, that's personally something that I greatly appreciate, but I don't think it's generally accepted at all, is it? That the international law is sort of malleable and not quite the same as domestic law, because it's a fairly important issue.
It absolutely is, and it's an issue on which we've given very clear guidance in a judgment in the past year. Some of you will be aware that child benefit is subject to a cap, that it's limited to a maximum of 2 children. At least the main element in it is limited to 2 children. And that was challenged before us, essentially as being contrary to the UN Convention on the Rights of the Child. Now, that convention has not been given effect by Parliament, except in certain limited ways which weren't relevant. And an attempt was being made effectively to import it on the back of the Human Rights Act. And we laid down in our judgment very clear guidance that we apply Acts of Parliament. It's an aspect of parliamentary supremacy that the government, it's the government, of course, that enters into treaties. So the government makes international law by agreeing with other governments. And according to parliamentary sovereignty, the government cannot alter domestic rights and obligations at its own hand. It has to go through Parliament and get Parliament to legislate. And that's why the Act of Parliament is essential, and the treaty doesn't by itself alter the law at all. And when I say at all, that's an overstatement. There are certain limited effects that a treaty can have, but it certainly can't override an Act of Parliament. And so in that case, well, there was a conflict between an Act of Parliament dealing with social security and a UN convention which Parliament had not implemented. It was pretty obvious which one trumped the other. And we've made that clear now. In a way it wasn't clear. It got rather muddied by some previous judgments in our court. So that's been clarified, and the lower courts now know where they are.
Thank you.
Okay. I think also, Lord Reid, you made a very clear statement on that point at the last session that we had last year. Yeah. I've just looked it up. It's very unequivocal in what you're saying. Once the statute is passed, then you apply the statute.
Yes, I feel more comfortable making unequivocal statements about the law than I do about political institutions.
No, but I reread that before we came today, and I think it's very clear in what you're saying. Lord Hope, I think you had a question on judicial appointment.
Yes, this is a topic that we come up with you every time we meet. I think this is the appointments process. Just to get our bearings, Lord Reid, you're a member of the ad hoc committee when it has to sit,
yes.
Am I right? But you're the only member of the court who is on that body.
That's right. It's laid down in legislation. I have to convene the commission and I chair it.
Yes. But otherwise, the other qualified people, judges, and is the chair?
Yes, there always has the chair is myself.
Yes.
That's laid down in the legislation. I have to nominate, and the Lord Chancellor is also involved. But I nominate another senior judge, and who I choose tends to depend on the nature of the appointment being made. Currently, for example, we have vacancies from England and Wales, and I asked the Master of the Rolls to sit. The previous time, it was another English appointment, and I asked the Lord Chief Justice to sit. The time before that, it was a Northern Irish appointment, and I asked the Lord Chief Justice of Northern Ireland to sit. So there's myself, one other senior judge, and then there are 3 lay members, each of whom is a member of the judicial appointments body, either for England and Wales or for Northern Ireland or for Scotland. And currently, well, the current commission dealing with the retirements that we've recently had is myself, the Master of the Rolls, Lord Kakar, consultant surgeon and a member of this House, who chairs the English Commission, Liz Burnley, who is an occupational psychologist by background, who is a member of the Scottish Commission, and Paul Douglas, who is a senior police officer by background, who's a member of the Northern Irish Commission.
Yes. Just to understand what has happened since last year, has the ad hoc body sat since we last met?
We sat on Monday of this week.
Oh, so there is a vacancy to be filled, is there?
Yes, there are 2 vacancies to be filled.
Yeah.
We held back the process until we knew where we were in relation to retirement ages. As you probably know, of course, there's been a bill dealing with that just recently, which has raised the age to the retirement age to 75. As part of the benefits of the remote working that we introduced during the pandemic, we've been able to hold most of our preliminary meetings virtually, rather than everybody having to come from Edinburgh and Belfast, or indeed Cardiff and Belfast to London. But obviously the interviewing was done person to person.
Yes. I've got two particular topics to cover. One for Lord Hodge, I think, is to go back to something we discussed with you last year, which is the possibility that the Lord Chancellor would have a more close involvement in the choice of candidates for the Supreme Court. Now, I think you said that any arrangements of that kind would have to preserve the perception of judicial independence because of his other responsibilities. Has there been any further thought given to the possibility of the Lord Chancellor sitting as a member of the ad hoc body?
There has been no discussion of that matter in the past year, as far as I'm aware. I know commentators have suggested that they would want a list of potential candidates to be submitted to the Lord Chancellor, rather than him sitting on the body, a list of appointable candidates to be presented to the Lord Chancellor, and the Lord Chancellor can choose from that. But we've had no further discussions about that matter, and one has to bear in mind that there won't always be necessarily a long list of appointable people for senior posts. But the discussion about appointments has yet to take place.
Perhaps I might add that it would be a mistake for members of the committee to think of the process as one which is insulated from politics. The Commission is independent, and we make a recommendation which is based purely on an assessment of the merit of the candidates. But we do consult the Lord Chancellor, the First Minister of Scotland, the First Minister of Wales. And we get meaningful responses from each of them. We also have a meeting with the Lord Chancellor at which he explains to us any concerns or priorities or factors that he thinks are particularly significant. And we then, as I say, we go through the process, make our recommendation. He then has to decide whether he's going to accept our recommendation or not. He's entitled to ask us to think again. He's entitled to reject our recommendation. And as part of his decision-making process, he also consults the heads of the devolved administrations, and obviously has his own input. And once he has made his decision, the matter then goes to Downing Street. So it's not an ivory tower process at all.
No. But the way it works is that he's presented with the choice made by the committee, but he's not given a choice himself. He can either say yes or no. So
he's given a full report, which will tell him what he knows, because he's a consultee, who applied. He's given our thinking process in deciding who to shortlist for interview, and then we explain to him very fully why we have selected one candidate out of that shortlist rather than another. And as I say, if he is dissatisfied, he can ask us to think again, but obviously he's confined to the people who actually applied. And part of the difficulty sometimes from a point of view of diversity is the narrowness of the group of people who apply.
Well, can I come on to diversity? At the moment, the court I think there's only one lady sitting on the court, whereas some years ago there were three. So at the moment it looks as though you're moving backwards, but then there are two vacancies to be filled, and obviously the candidates who are available will be looked at, and you would apply the usual tests. But I wonder if you could expand a little further on your efforts about diversity.
Yes, certainly. They are partly focused on appointments to the court, but they are also very much focused on longer-term progress. The problem with appointments to the court is partly that as a result of the raising of the retirement age, there aren't going to be very many during my time on the court.
Can you put any figures on this? I mean,
well,
you've got two vacancies just now, and is that likely to be the last opportunity for some years to come?
Absolutely. And one of the people who retired is entitled to reapply for his old job. So there are going to be... I mean, it's made a massive difference, frankly, to diversity, because, I mean, until recently, Patrick and I both had to go at 70, which is not that far off, a little bit further off for me than for Patrick. But now we can stay on until 75. And, you know, if you're continuing to find the job interesting, then people do, as indeed yourself did.
Yes, I know.
So the scope for appointments from the Court of Appeal and its equivalents is very much reduced over the short term, well, say over the next 5 years. And at the same time, those are not notably diverse courts themselves. So there's no guarantee that you're going to recruit a radically different set of people in appearance from the existing ones. But we are doing what we can. So far as women in particular are concerned, I can say two things I've done in the last year. One is to discuss the issue. Well, first of all, I went myself to go and speak to the Court of Appeal judges to try to encourage them to apply, and because there is a reluctance to apply.
Why should that be?
I think it's because people are reluctant to apply unless they feel they are highly likely to be appointed. They're not people who are used to failure. So that's one problem. But I went to speak to them. Secondly, I've been inviting judges from the lower courts and to a disproportionate extent women to sit with us. Now this is something that's new, but over the last year I've invited 15 judges from the Court of Appeal or its equivalents to sit with us. 7 of those were women, and one of those sat with us twice. So women have been more than pulling their weight, as it were, as a proportion. Of course, they're well below 50%. So if I've been inviting 50% women, that's been favouring them. But the idea is to demolish some of the myths about the court, let them see what it's really like to work with, and hopefully they find we're a friendly bunch and it's interesting work and they think about applying. The third thing has been to discuss the issue with the woman judge on the Court of Appeal, who is responsible for diversity and inclusion in the Royal Courts of Justice, that's to say the Court of Appeal and the High Court, and discuss with her why women are reluctant to apply. It's perfectly obvious that they are. And so we've explored the reasons which she thinks there are. I have to say that they're not ones that are readily capable of being addressed. They're to do with, in some cases, first of all, we're talking about quite a small sample of people. And for some of them, it's personal reasons of an individual character. For some, it's a reluctance to do the kind of work that the Supreme Court does. It's a very intellectual place, and it's also a place where you have to do everything, but some things more than others, and particularly you do commercial law and the sort of work I've been describing. We do hardly any family law, which is an area where women have historically specialized. We don't do very much medical negligence or the like, which is another area where women have tended to work. We don't have very much crime in the Supreme Court, although there is crime in the Privy Council. But again, that's an area where you tend to find that women have experience. Now, these are broad generalizations, but you know, I'm talking about only a small number of women actually in the Court of Appeal. So there are personal reasons to do with the sort of work you like to do. There's also a feeling that it's a step up in terms of the amount of work you have to do when you come to the Supreme Court. Not everybody is keen to do even more work, perhaps especially women who are of a certain age and have family responsibilities and so on. But obviously there are more women coming through. There are more women coming through with the sort of background where they would be comfortable in the Supreme Court. Some of them haven't applied in competitions because they don't feel they have sufficient seniority in the Court of Appeal.
Could I ask you about ethnicity? Because, of course, one's got to bear that in mind too.
Yes. Well, in relation to that, we have, for example, we have posted on YouTube. You only have to look at our website to find all this, I should say. So anybody who's interested in the court can find it quite easily. We've posted on YouTube a series of videos made by members of the court explaining their background, their route. One of those, at least, is made by one of the women judges, and explaining what the court is like, what the appointments process is like, and so forth. And we organised a careers webinar, which I did with one of the women on the court, with our woman on the court, Lady Rose, and with Liz Burnley from the Selection Commission earlier in the year, which had a very large uptake. We got 1,000 people signed up for it. About 400 actually attended, and it's been viewed over 1,000 times after that online. And our feedback shows that most of those who viewed it were women, and about half of them are for an ethnic minority as well. And it was aimed really at early and mid-career lawyers, explaining to them how to try to prepare themselves if they wanted to get to the court at the end of their careers, and what sort of career choices made sense. And also what sort of people we were looking for, what skills were required, and what the actual process was of applying for a position.
Just one final point. Judicial assistants, and I see,
Yes.
I'm very happy to see you've got a large number of them here, and obviously diversity is being achieved there.
Yes.
Is it something deliberate, or is it just where things are developing, that in fact you're getting more people applying from diverse backgrounds for that particular appointment, which is the beginning of a career, isn't it?
That's exactly it. That's exactly it. I mean, we go out to universities, and indeed schools for that matter, and we do sessions with school children online first thing in the morning, usually with sixth formers, and they're often people who are thinking about studying law at university. And you find very bright people from all sorts of backgrounds and ethnicities, and it's our role to encourage them. And equally at university, you sometimes get asked difficult questions. You know, will I face discrimination, for example, was a question I was asked by a young black sixth former. But we are engaging, and I think we're putting out a message pretty strongly. If you're interested in the court and actually look at our website, you'll find all this, that we are encouraging and supporting diversity. I should say another thing we did over the past year was to introduce internships, paid internships at the court, specifically for young lawyers from underrepresented groups. Each of them was assigned to a justice and a judicial assistant, and they spent a week with us. And at the end of every day, I would go and speak to them about the case we'd been hearing, the law, and also the advocacy. And it made a very obvious difference, even by the end of the week, to their self-confidence, that they were saying that they were unused to being listened to in a respectful way, where they felt their views were being valued. And as one of them put it, if we're treated like that in the highest court in the land, then if we're not treated like that elsewhere, it's not a problem with us.
Thank you very much.
Okay, just two more contributions on that. Lord Howard and then Lord Faulkner.
Lord Reid, when you and your colleagues on the appointments commissions consider candidates for the senior judiciary, do you take into account whether their judicial history shows a tendency towards activism or a tendency towards restraint?
I would take that into account. We ask, well, for example, when we were for the exercise this week, we asked them to give a presentation on judicial activism and its impact on the relationship between the courts, the government and Parliament. And we're expecting them not only to talk the talk, but to walk the walk, if I can put it that way. And so you do look, I mean, obviously the judges, myself and the Master of the Rolls, are well aware of people's track record, and I certainly take that into account.
And it would be entirely legitimate for the Lord Chancellor to take that into account in deciding whether to accept or reject a recommendation.
I suppose it is. If you've shown that you understand what the court's constitutional role is, or if on the other hand you've shown you don't understand it, that must be a material factor.
I take it you'd agree that it's important that candidates should have a judicial history.
Yes, I do. We in fact now put that in the pack that goes out to candidates, that this is not an entry-level post. You are expected to have significant judicial experience.
One final thought. Would you agree, I think it's an indisputable fact, but you may disagree, that there's far less accountability for such appointments now than there was before 2005. I remember being struck, listening during the coalition, to a minister from the Department of Justice being attacked on all sides in the House of Lords for the lack of diversity in judicial appointments, and reflecting on the irony of the fact that under the post-2005 arrangements, neither the minister nor really any other minister in his department, save for the residual responsibility which we've touched on, had anything to do with these appointments. Whereas before 2005, he could have been questioned. It might even have been the person responsible for making the appointments who could have been questioned and been accountable.
I have to say I don't take that view. I think the minister's responsibility is a real one. I was rather dismayed, as you probably know, the Policy Exchange issued a paper on judicial appointments last year with a preface by a former Lord Chancellor who said that he'd received a recommendation once for a senior judicial post of somebody who he knew was hopeless and temperamentally unsuitable and so forth. But he had been advised that he ought to rubber stamp it, and so he had rubber stamped it. Well, I don't intend any disrespect to that individual, quite the reverse. But my view of the minister's role is not that. I think it's a very important responsibility to sign off appointments to the highest court in the land, and I would personally expect the minister to take it very seriously, and if he is concerned, to raise these concerns with the selection commission, and if need be, ask them to think it over again.
We'll have the opportunity to ask him that question when we see him. Lord Faulkner.
Including looking at the judicial record of the judge and deciding he's too activist to be, or she is too activist to be appointed to the Supreme Court. Surely not.
Well, it's a question. The merit criterion is obviously concerned with judicial ability.
Yeah.
But
they're to be appointed on merit.
Yes, appointed on merit.
Yeah.
But those criteria also include having a sound understanding of the constitutional relationships. That's all I'm meaning. I'm not meaning whether somebody is more or less keen on developing, I don't know, the law on psychiatric injury, for example, or vicarious liability, or whatever it may be, or for that matter, is more or less likely to have overturned the Home Secretary on a deportation case. That's not what I have in mind at all. But they do have to demonstrate, and we specifically test them on this, a proper understanding of constitutional roles. And if somebody's record, I mean, if I'm aware that they've been issuing judgments which demonstrate a lack of such an understanding, then yes, I would take that into account.
That's very helpful. I mean, the way Michael answered the question, could activism be bad and conservatism be good? Yes. You're saying no, it's the question of understanding what the implications are of what you do, whether it be conservative or activist.
Yes, I mean, obviously part of a role, a very important part of a role of a Supreme Court justice involves the development of the law. And so another criterion is creativity. I suppose one person's creativity may be another person's activism. But we are looking for individuals who have demonstrated an ability to think creatively and to develop the law, but who also understand what a judge's role is and understand that it's not the same as a politician's role.
Just go back to one thing you were saying before. I can imagine a committee with the President of the Supreme Court, the Lord Chief Justice of England and Wales, and a consultant surgeon, and a police officer and a psychologist, when they're choosing who the next person to be the Supreme Court Justice is, when the Lord Chief Justice of England and Wales and the Supreme Court President knows all the candidates and the other three don't, the lawyers, the judges, will predominate to an undue extent. Do you think that happens as a matter of practice?
No, I don't. I don't want to talk about the contributions of individuals, but the lay members do play a very active part in the discussion. And because we're testing, we're not just testing on legal ability. On that area, I would expect them in practice to defer to myself and the other senior judge. Although we give them, they get the same judgments and they read the judgments, but they'll comment on things like how well the person communicates, how easy it is to understand the judgment, that sort of thing. But we test on personal qualities. You need somebody who can work collegiately, for example, somebody who can relate well to people from different backgrounds, somebody who's willing and able and suitable for doing outreach work with schools and students and general public, and skills in so these personal qualities, communication skills, ability to work as a team player. These are areas where, for example, you can see the role of an occupational psychologist being relevant very obviously, but all these people use their experience of life. The exercise is a very thorough one. They get the chance to assess these individuals in front of them, putting questions to them, and comparing one with another. And in practice, we tend, with nuances, to be broadly of much the same view about how people have performed and how well equipped they seem to be for the role. It's certainly not a question of the two judges making up their mind and the rest just going along with it. That's not the position.
Lord Reid, in your outreach work, you were asked by a young black person, shall I face discrimination? What was your answer?
I said no. I mean, they won't face any greater discrimination in the law than they would in other fields, possibly less. It's a very market-driven profession. If you're good at the job, you'll get on at it. It's very important for us to be encouraging people and not putting them off. They're not going to encounter discrimination from people from judges. I don't think they're going to encounter it from. But I certainly hope they wouldn't encounter it from the bar, which is where it's really very often or indeed the solicitor's profession. But faced with that, I mean, frankly, that question brought me up short because I had to think: do I give an elaborate, honest answer and say, well, you must be familiar with the fact you face discrimination as it is in your daily life, and that's the nature of our society. You're not going to find it any worse in the legal profession than you will anywhere else, and you should go for it, despite any problems that may be in your way. I mean, that's one way of answering the question. Another way is to be upbeat and say, no, go for it. There are lots of black people coming into the profession now, which is true. There are black judges now, which is true. It's getting easier all the time, and you should go ahead with your plans. And, faced with somebody who's 16 or 17, I give the simple, encouraging answer rather than the more nuanced one.
I hope you won't get a comeback on it then.
No, I hope so too.
Could I just ask one quick question on this? I mean, you have a stock and a flow problem. You don't have the people now, and you need to make sure the people are coming through for the future. Is there a strategy that actually identifies barriers in the flow line for people with different characteristics and a systematic way of setting about how those barriers are going to be addressed? Because it's not only in the attitude of the individual that may be the barrier, it may be processes or culture.
Yeah.
And unless the territory's been mapped and a strategy for dealing with barriers in that flow line, I wonder if any thought had been, just as an exercise, I'm not going in for the detail.
Well, we focus on the things that we can change, either directly or by setting an example. There are factors which we can't change. For example, statistics demonstrate very clearly that women are under-instructed in front of us. It's mostly men who get instructed to appear in the Supreme Court, and that reflects behaviour in the solicitor's profession, who they choose to instruct. I can't control that. There are currently 7 female black QCs. That's a 40% increase on a couple of weeks ago when there were only 5. For male black QCs, it's not much better. I think there are about 20 or 22, something like that. Now, why are there so few? There are reasons to do, I imagine, with social mobility, which we can't do anything about. With a host of social factors that lie behind that, but there may also be factors to do with offers of pupillage by barristers' chambers. I can't control that either. What we do is we try to set the best example that we can, try to overcome barriers which may put people off applying to our court, and I hope I'm setting an example which other courts will follow. And as I say, we do what we can. I mean, compared with a lot of organisations, we do a very great deal to engage with school children and students and young professionals. to try to encourage them and support them. We're in year one of our, we've completed year one of our strategy, and we're moving in the right direction. We have built links with groups like Bridging the Bar, which is a barristers' organisation to support people from underrepresented groups, and the Black Barristers Society, and equivalents, to try to find out more about how we can best try to address these problems. So it's a work in progress, but I can assure you we're taking it very seriously.
I don't doubt that, and I wasn't offering criticism. I was just reflecting on the fact that we focus on the judicial appointment process, where actually the solution lies with a wider range of players.
Absolutely. There are only a tiny number of people who are ever going to be appointable as Supreme Court justices. But the legal profession is, there are, I think, 350,000 people in the UK employed in either as lawyers or in legal firms or chambers. So it's a very large number of people. So we can influence behaviour in a way which can have much wider benefits than, without underestimating the importance of a more diverse Supreme Court. That's a more, if you like, representational issue to do with public confidence, and to some extent with decision making. But there's a much larger group of people out there who we can benefit.
Someone somewhere, and it isn't just the judicial appointments bodies, needs to own, I think, that broader strategy. But I think that's maybe something we can maybe even raise with the Lord Chancellor. Lord Foulkes, we're back to you on
yes,
the
thank
reviews.
You. Since you gave evidence last year, the Judicial Review and Courts Bill is going through Parliament. I think its third reading is, in fact, this afternoon. And I'd like to say on behalf of my committee, we're very grateful to have the contributions from the senior judiciary to that consultation. And I'm sure Sir Peter Gross would say the same about his inquiry. They were helpful in terms of the constitutional propriety of any recommendations that we might or might not have made. Would you have expected to have been involved any further than in the way that you were involved?
I don't. No, not really. Subject to a point I've already mentioned, actually. We were very happy to provide responses to the two reviews, because you were really, at that stage, at least what we were offering you was really information, statistics, and information about developments in the law or trends in the law. And I did the same for Sir Peter Gross's review. And I was also able to give him some practical help by giving him introductions to foreign judges whom he wished to interview. Beyond that, once it got to the stage of the government's consultation papers, we pulled back because they were putting forward policy proposals, and they weren't, it's not our role to offer views on government policy, particularly in such controversial areas. There has been, as I mentioned earlier, some engagement with MOJ officials over what you might call nuts and bolts implications for the courts. But that has operated within well understood boundaries.
And just one final question on this. The suggestion in our report and reflected in the review is that it is perfectly constitutionally in order for Parliament to decide to reverse a particular decision of the Supreme Court. That's parliamentary supremacy, although some people have suggested in some way this is contrary to the rule of law. Could you confirm that we did get that right, at least?
Yes, I think you got that right. The classic example is the War Damage Act of 1965. There was a case to do with compensation for property that had been destroyed during the Second World War in order to halt the Japanese advance in the Far East. And the government warned the House of Lords Appellate Committee that if they lost the case, they would then immediately legislate to overturn the House of Lords' decision. The House of Lords went ahead anyway and decided the case called Burma Oil. And the War Damage Act was promptly passed to reverse it. The same happens every year, actually, in the Finance Act. The Inland Revenue sort of tot up the cases they've lost over the previous year and identify the ones that they think really matter, and then they, as it were, put the courts right in the finance bill.
Thank you very much.
Thank you. Lady Fuchs.
Lord Reid, you mentioned earlier this morning the work with the Speaker's office, and you also mentioned it in last year's evidence. Yes. Could I ask you to elaborate on what has taken place and how successful it has been?
Yes, certainly. Well, the Speaker suggested that the first step we might take in engaging with members of Parliament was to invite members of the Justice Select Committee of the House of Commons to come to the Supreme Court for a visit and a discussion. And we did that. It was a very successful event. We had timed it, I think, to be an hour and a half, and in fact it went on for an hour longer than had been planned. And that reflected the degree of interest that there was. And I was very pleased to see how well attended it was also, because I mean, we realise that MPs are very busy people. And we're now discussing what to do next. We have it in mind, we have identified another committee which is likely to have a particular interest in our work, and so we have it in mind to invite them over for a similar visit and discussion. I've also been holding meetings with the Lord Speaker, and they've resulted in his inviting me to give a lecture in his series of lectures in the early summer, and to speak about the rule of law and its interrelationship with democracy. We've held 2 seminars with Parliamentary Council on statutory drafting. And these have been very valuable for us. We get taken to a lot of material of a kind that didn't used to be referred to very often. For example, explanatory notes. And I, for one, had not realised until the seminars that there were 3 different categories of explanatory note, dealt with in different ways within Parliament, and therefore with differing degrees of significance from our point of view as an aid to interpretation. So we've had these seminars. We've also done it the other way around. Some of our officials have come to Parliament to do seminars there with, for example, people in the Speaker's office. We took part in the autumn for the first time in Parliament Week, and to raise awareness of the court, and our role in that was, as you might imagine, to emphasise the importance of the rule of law in a democracy. And our programme comprised, we focused on education, and so we ran tours for staff from the Department of Education, so they could see what we do in terms of materials for children and lessons for children. So we run lessons in the court. And we also had organised a debate day for schools. Yes, and our communications team have also been engaging with the House of Commons Communications Academy in explaining how we go about trying to explain the work of a court to a wider community. So there have been quite a few steps taken, and I'm keen to build on these.
Have you considered engaging with the Delegated Powers Committee in this House? Because I confess that I was formerly its chairman and a member, so I have a vested interest. But it's a very interesting slant on the way governments bring forward legislation.
Yes. I should have thought of that because I used your report on the COVID legislation. It was a very useful source of material on that. I should have thought of inviting you, but I hadn't. It hadn't occurred to me. But that's now added to our list.
I wasn't thinking an invitation to me, but an invitation to a committee of which I'm no longer a member.
Yeah, yes, I meant.
But I thought
it
could be a useful, different approach.
Yes, yes, I meant the committee, and certainly I see the value of that.
The bar was raised when you did chair it, Lady Fuchs. Lord Hennessy, you had a question.
Thank you, Chair. Could I ask you a couple of follow-ups to Baroness Fuchs's questions? Just a quick one, first of all. Do you remember when Charles Clarke was Home Secretary, he suggested that the senior judiciary might have dinner with him and a couple of other ministers so that they could take each other's minds more effectively? It was a suggestion not greeted with rapture, to put it mildly, by the senior judiciary. If you'd been a player in that request, would you have said, yes, let's have dinner? Or in other words, have you changed your tone and pitch about where the boundaries are drawn in that particular instance?
I'm not sure that I would take a different view. I think one wants to avoid becoming too chummy with ministers. There has to be a certain distance. You want to have a cooperative relationship, but we're not friends. We do. I mean, I have to say, we do invite the Lord Chancellor to an annual dinner that we hold, and it's a chance to meet the Lord Chancellor and his partner socially. But I think it's probably a good idea to maintain a certain distance.
Thank you. A slightly longer question, following up Lord Howe's earlier question. I think there's a hidden river beneath many of the questions we're discussing today, and indeed our wider inquiry into the Law Office of the Lord Chancellor. And it's this, that the two professions, the legal profession and the political profession, are very different in all sorts of ways. They attract different people. Their use of evidence is very different, and the way they express their use of evidence is very different. And so the formations of the two professions over the years, as you rise up their hierarchies, are very different. And one of the things that we expect our law officers to do, and indeed our Lord Chancellors until recently, is to have the kind of temperament and experience that bridges those two professions. Do you think there's something in that anthropological explanation that I'm offering of the difficulties and tensions that we've been skirting our way, waltzing around this morning, and in our wider inquiry too?
Yes, I do. In fact, in the judgment I mentioned earlier about child benefit, I wrote at some length about what I saw as the differences in approach and reasoning and the like between a parliamentary process and a judicial process. And as you say, that becomes ingrained over 40 years of a career. Possibly for that reason, I've certainly found it helpful that the Lord Chancellors I've had to deal with as President or Deputy President all had some legal experience, some more than others, but they all had a legal background and some legal experience, and they at least understood where we were coming from, and they had internalized some of the same values as the judges hold.
Would it be helpful to, it's not really a request this, I'd be fascinated to see it if you could do it, to write another article describing the things that the politicians you think least understand about the judges and vice versa. Get it out into the open. For example, Lord Reid, what do you think you're most parodied about? How do politicians most parody you? What's the particular stuff that they hurl at you?
Parody. How do they most parody you?
Parody?
Yeah. Parody.
How do you most see politicians parodying judges?
Misrepresent.
Well, well, I suppose one of the things I explained in the judgment was that politics is the business of compromise, or it's an intensely pragmatic business, as I see it, and trying to achieve the best, try to get as close an outcome as you can to what you would like, and if need be, not being too squeamish about how you achieve it. And you're not going through a punctilious process of reasoning, but it may involve rather hard-nosed bargaining, the offers of favours, threats, and ultimately you emerge with an outcome which will command general acceptance, or at least sufficient acceptance to get it through Parliament. Whereas we inevitably are much more
is fastidious the word you're reaching for, perhaps?
I'm sorry?
Is fastidious the word you're reaching for?
Well, principled was the one that I came up with, but I think fastidious might be a politician's way of describing it. So, yes, they're very different processes. You have to get your hands dirtier, I think, as a politician than we do as judges. And at the same time, you're exposed to public criticism to a far greater extent than we are.
Thank you very much.
Have you finished, Lord Hennessy?
Yes, I have, thank you.
Okay, thank you. Well, if we could move on to the future of the Supreme Court. Lord Sherburne, you had a question.
Thank you. From time to time there is speculation, suggestions in the media and from politicians about how the Supreme Court could operate or be structured differently. Without you giving me a specific answer, in general, are there various suggestions about how the court might operate or be structured in a better way, which may not be within the remit of the court itself, which you think in your private moments, gosh, that's a good idea?
I have some ideas, and I've been putting them into practice about how the court might be improved, but I haven't had any structural ideas of that kind. The closest I've come to that, really, is in relation to the Privy Council, which takes up about half of our time and our work. I'm acutely conscious that we are 12 British people from British culture sitting on appeals from countries which are very different from this one. And sometimes that becomes very obvious. For example, we had 2 cases recently about same-sex marriage, which is an intensely controversial issue in the jurisdictions which the cases came from. Religion, generally, is something which is, I think, of more central significance to society in some of these jurisdictions than it is in this country now. And the suggestion I've put forward is that we should be enabled to invite judges to sit with us who actually have experience of sitting in these countries. I would very much, this used to happen with judges, for example, from India sitting in the Privy Council, or Ceylon as it then was. But it doesn't happen now, and in fact it can't happen now because there aren't any who are Privy Councillors whom we could invite to sit. So I've proposed a way forward on that, which would give the Privy Council a rather different look. And that's currently with government for consideration. I haven't had any such Damascene moment in relation to reforming the Supreme Court. My feeling is it works generally well. It's a pretty new institution, actually. It works pretty well on the whole, there is a bit of there are improvements that can be made, and obviously I've made quite a lot of changes in terms of our external relationships, and the COVID pandemic has encouraged us to make major internal changes to how we work, and we are planning to make more changes to how we work internally, but there's nothing dramatic.
Good, thank you, that's helpful. Could I ask a follow-up question? Are there any suggestions that occur to you, again, in your more private moments, about how the law officers, which is what this inquiry is ultimately about, how the law officers, I'm not talking about in the current holders of those positions, but in general, how in your private moments you think the way in which those office holders are, their status, their responsibilities and how they operate vis-à-vis the Supreme Court could be better?
Well, I see the law officer's role as primarily being to provide legal advice to government departments, and in that way to ensure that government departments keep on the right side of the law. We engage with the law officers by having regular meetings with them. I've been particularly conscious of the importance of the role of the law officers in the devolved administrations, because it's up to them really to keep those administrations well informed about the limits to their powers and avoid the sort of constitutional problem that might have to come before us for decision. And also, if there are cases which the devolved administrations lose in our court, it's, I think it's part of the law officer's role to explain to explain to their colleagues in government why they lost and what the implications are. And I hope to make our decision accepted, albeit perhaps reluctantly, but nonetheless as an honest application of the law. It can be a useful two-way process. I mean, again, I'd have to say my most fruitful discussions have been with devolved law officers, but I remember one of the Scottish law officers raising with me the level of awareness of devolution amongst the English justices, which he thought was rather low, and things that had been said during a hearing of a devolution case had tended to support that assessment. And so I've responded to that by, since then, always including one of the English justices when I have a meeting with any representative of the devolved administrations, so that they're aware of issues that are arising in Northern Ireland or Scotland or Wales, as it may be, and are much more aware of devolution as a reality. So I think a lot of English, well, certainly amongst my English colleagues, the awareness was not previously as well developed as it was amongst the Scots and the Welsh and the Northern Irish. So it is an important relationship. I see our meetings really as a communication of information each way, and I see their primary importance from our perspective as being in the way they advise the administrations that they are part of.
Thank you. Lord Howarth, I think you had an additional question on this.
Thank you. Some lawyers have suggested that the Supreme Court has inappropriately taken upon itself to be the ultimate authority on constitutional matters. Mm-hmm. Do you so consider yourselves? Or is it perhaps the case that with an unwritten constitution, there cannot be such an ultimate authority, and the determination of constitutional issues is a matter of debate and the outcome of politics and the interplay of different institutions and power centres, and not something any one authority can opine upon.
Well, I would take the latter view. Dicey's classic division was between constitutional law and constitutional conventions. And the constitutional law is partly statutory, it's very largely common law. We are the final arbiters on the common law and indeed on the interpretation of statutes. And so we inevitably have to be the final arbiters of issues of constitutional law. But there's also, Dicey was right, there is a great deal that's important in politics that depends on convention. And that's a matter that's resolved within the political institutions themselves. We've had some interesting cases recently, which rather illustrate the point. There's one which hasn't reached us, and I don't know if it may, so I won't express any view about it. But if I just say there was a challenge to the Prime Minister's decision to retain the Home Secretary in the government, notwithstanding allegations against her, and the court, not our court, but the court, was being invited to effectively treat the ministerial code as raising justiciable issues. That's so you can work out, I dare say, where Dicey might place that issue. We had another similar. Curiously, these cases are often brought by MPs. We had another one recently in which we refused permission to appeal that had been brought by 2 MPs, which again had raised an issue which, depending on which way you looked at it, might be regarded arguably as legal or might be regarded more accurately as a question of convention. A curious thing is we don't go looking for cases, of course, they come to us, and it's not unusual for the cases which might tempt a judge over the boundary to be brought by MPs.
Trying to invoke you as political players.
Exactly.
Wealthy.
Thank you. Right, well, Brexit. Lord Robertson, you had a question.
Yes, last year when we were talking about the challenges to the court, the implications of Brexit were still being worked through at that point, and clearly there are major issues of principle and practice concerned with the application of existing a European Court of Justice law, and you said at that time it was too early to say, so maybe you could give us an update on the court's thinking now.
Yes, I can give you an update. We still haven't had a case in the Supreme Court which raises any of the issues that you have in mind. We currently have some before us where permission to appeal is being requested, and we haven't decided yet whether to grant permission. But we did have an interesting case which came to us in the Privy Council from Gibraltar. And EU law, of course, applied in Gibraltar. And the case arose prior to Brexit. But Gibraltar, of course, left the same way as the UK did. And the result of Brexit was that when we had this case, which raised rather a difficult question of interpretation of an EU directive to do with electronic communications, we, of course, could no longer refer the question to Luxembourg, as we would have been required to do until Brexit. And so we had to decide the question for ourselves. And it made us conscious of the fact that if it had gone to Luxembourg, the court there would have heard submissions from the European Commission, which would have been responsible for drafting the legislation and would have been familiar with the policies that it was meant to implement, and also submissions from the member states. And the court would then have taken a decision in the interests of the EU as a whole, designed primarily to promote the single market. Now we, of course, we only had submissions from the individual parties to the case. So we couldn't undertake the same exercise, and we couldn't be confident at all that we either could or even should arrive at the same answer as a Luxembourg court would. So we did our best, and we gave an answer. But as I say, it may not be the answer that Luxembourg would have arrived at. But it struck us, if the same point had come up in the UK, how we dealt with it would have depended on which part of the UK it arose in. If it had been an England and Wales case, or a case at least concerned with England and Wales, we'd have had to deal with it in the same way as we dealt with the Gibraltar case, and similarly with retained EU law. If the case concerned Northern Ireland, then we would have been required to make a reference to Luxembourg, because the protocol requires that. So we could end up in a situation where the same piece of legislation could be given two different meanings within the UK, depending on which part of the UK is relevant. It's a rather curious situation, but there it is.
If it was a directive, then the directive would have been put into domestic law.
Yes.
So there would have been there would have been a previous interpretation put in place at that time, wouldn't it?
Well, there would be a piece of domestic legislation. It usually, and in this case did, simply repeat what the directive said, and you're required. This was a pre-Brexit case, yeah. And so we would have been required to interpret the legislation in accordance with the directive, and so in reality you're interpreting the directive. As retained EU law, I mean, the directive itself would now be, it would have a sort of Union Jack put round it, but it would be, the directive would now be a piece of retained EU law, and we would be interpreting it. But in Northern Ireland, it wouldn't be retained EU law; it would still be EU law, and that different status would mean it would be dealt with by a different court ultimately, and be a different answer possibly arrived at.
So you're beginning to now look at the implications in advance of cases that might come forward.
Well, they're beginning to dawn on us.
Can I ask you, go back to your opening submission, because I was curious at the time, but I didn't want to interrupt you. But it might be relevant here as well. When you said that you had this case that had nothing to do with the United Kingdom.
Yes, with lots of them.
Where they choose to land the case with you. And that's a bit of a mystery to me as to why that would be, what would be the case. But would that not mean that you could have cases that would also be to do with interpreting ECJ rulings? If somebody decided they weren't happy with what Luxembourg was saying, they would decide to land it with you on the basis that you might give a different answer.
Well, that's a very interesting possibility. That isn't how things work in practice. What happens is, if you take the Russia-Ukraine case as an example, Russia and Ukraine entered into a commercial contract worth billions of dollars. and they selected English law as the legal system that would govern the contract. And that's very common. English law is effectively it's like the English language. It's become a world legal system for international commerce. It and some American systems. So they choose English law to govern the contract. They also choose the English courts as a jurisdiction where any proceedings must be brought. And so the case ends up with us. And that's true of most of these. The shipping case was the same. The French and German company entered into a charter party which was governed by English law and had a choice of the English courts as the courts for any litigation. And so the case comes to us. And there's a colossal industry in the City of London, as the legal members of the committee will know, providing legal services to the rest of the world, particularly in relation to commercial disputes. And so in a sense, they forum shop. They like English law. They like its predictability. They like the integrity of the judges and the expertise of the judges. And so they choose to litigate here. If it were a case whose natural home were the EU, I'm not so. Then you might end up with some interesting problems. We have a case, for example, at the moment. We haven't heard it yet, but we have a case where there is a tussle, essentially between the English courts and the European Court in Luxembourg as to which one ought to deal with a particular dispute. And the English courts have granted an injunction to stop a party litigating any further in Luxembourg. And there's an issue for us as to whether we uphold that or not.
Interesting to hear the outcome of that.
Yes.
So in effect, the answer to the question is you have not yet assessed any huge increase in your workload.
Oh no.
But you're anticipating these things might come down the road.
Yes. Sooner or later, we're going to have a substantial number of cases raising these sorts of new EU questions. I'm sure.
Thank you.
Yeah. Lord Hope.
Yes, my question is about the effect on you, the justices, of media portrayal of your decisions, public criticism. And I got an impression of your sensitivity to the issue when you used the phrase in answering a previous question about the reluctant acceptance of your decisions in devolution cases. Now, the question really is perhaps rather more personal than that. How confident are you that the judiciary can cope with criticism of that kind? And if it came to the bit, does the court itself provide any help to justices who feel under attack?
Well, I think there are a number of points to make. First of all, justices do have a degree of resilience. It's actually one of the criteria for my appointment and for Lord Hodges' appointment, but not for the other justices. But there is a degree of resilience. Secondly, it's unusual for us to be singled out individually for criticism. The complaint tends to be, the court has taken some crazy decision.
Is that true even in Scotland, where I suffered it?
Yes,
I was
I remember.
personalised a lot in my cases.
Yes,
are you immune from that?
I remember that. Well, I did. I was amused to read a comment in one newspaper that I had a Scottish background, and sort of admitting the fact I'd lived and worked there for the first 55 years of my life. But secondly, I think we have to. You have to put it into perspective. Some criticism in public life is inevitable, and frankly, we get off lightly compared, for example, with MPs, I think. As to support, our comms team do try. They will explain our decisions to the media in terms which the media can understand, and answer the media's questions so far as they can, which can disarm some criticism in advance. Sometimes we respond to criticism, not very often, but we occasionally do. And beyond that, I think it's largely down to the leadership in the court to create an environment where people feel that they are supported, and we all have each other's phone numbers, we all know each other very well, we're friends. So you're not going to feel isolated if you do get singled out, but it's in reality it's very unusual. And if it's aimed at, or for example, we were hung out to dry in some sections of the media over the prorogation judgment, but if it's aimed at all of you, well, you all bear the brunt together.
Yes. Are you conscious in framing your decisions that you are designing them to react to previous criticism? I mean, do you feel the need to explain more fully what you're doing in the successive cases? And if so, would you regard that as a good thing rather than an unfortunate reaction?
Well, as I mentioned earlier, I at least have made an effort in judgments over the last couple of years concerned with constitutional matters to spell out what the constitutional relationships are as I understand them. And that has been a response to the criticism, because it was evident that our role, people didn't understand our role, at least as we saw it, and so it's criticism isn't all bad, even if it's adverse criticism, and you can build on it by responding to it, and we've done that to some extent.
Okay. Could I just add
yes.
to that I do think we need to keep in perspective the criticisms that are levelled against justices. Cases that come to our court because they're difficult, and if they involve matters that have political consequences, people are going to take different views about the outcome of the decision. And we're acutely aware that we don't have the same level of criticism that parliamentarians are subjected to, some of the toxic things that are said in social media about members of parliament. On the whole, we are not exposed to. And most of the criticism of our work comes from the traditional media and political commentators, and tends to relate to cases that have political consequences. No doubt we are exposed to criticism in social media, but we are encouraged to have nothing to do with social media. So if we are being criticised, I, for one, am not aware of what's being said. And as Robert has said, if there is something that is disturbing us, we can talk to our colleagues about it. And we also have a very good comms team who can advise us on an appropriate reaction. But getting back to an earlier discussion, it's very important that we don't enter the fray in face of political criticism, and we leave that to the Lord Chancellor, if necessary, to defend us in the context of defending the rule of the law.
Yeah. We also, you'll appreciate the public law cases on which a lot of the discussion today is focused are a very small proportion of our work. Yeah. And the rest of both of those cases and all the rest of our work is subject to perpetual criticism in the law journals. Professor Endicott is not alone. The law professors, needless to say, judges get it right is not a headline you read very often. We're used to having our intellectual capacities, our understanding of the law and so forth severely criticised every week. What's said about us in the newspapers from a political perspective is just another part of the overall picture.
Thank you both very much.
Okay, Lord Howell and then Lord Hall.
I'll forego my question in the interest of time, because I know you want to get to the last question.
Okay, Lord Proctor.
you said a lot of criticism is good. You would be the only institution in the world that wouldn't be changed by the press environment over a period of time. I'm very struck by the comparison between the Belmarsh decision, which Lord Bingham's, when he was the presiding member of the House of Lords, he essentially overturned a decision of the government on how to deal with terrorism. It was a declaration of incompatibility, even though Parliament had completely backed the decision, and he got quite little criticism for that. Your court, in the child benefit case, which you touched on in what you said Parliament, having decided there should be a 2-child limit, irrespective of the law, said it would be inappropriate in those circumstances to make a declaration of incompatibility. And you gave a description of the 2-child case being one where the advocates had been campaigning outside the Supreme Court for the very same arguments that they made in the Supreme Court. Just in fact, as it occurred in the Belmarsh case, where similarly pressure groups had campaigned against the government's proposals and then made submissions to the House of Lords Judicial Committee at the time. Does that, I don't want you to comment on either of the two cases, but does that not reflect the Supreme Court retreating, as they would see it, from politics? Will there never be another declaration of incompatibility?
No,
because the declaration of incompatibility involves saying no to Parliament on primary legislation.
No, quite the reverse. If I could... First of all, the two cases you've mentioned raised completely different issues. The issue in the child benefit case boils down to how generous should social security benefits be. That ultimately isn't a justiciable issue. That's what we said. We said how much the taxpayer should be expected to contribute to the upkeep of other people's children is not a matter for decision by courts. It has to be a matter, it's obviously, we point out it's a matter on which views differ greatly in our society, and the place where those differences of view get resolved isn't the Supreme Court, it's here, in this building. The Belmarsh case was a fairly straightforward, if I may say so, case to decide. The problem with the legislation in that case was that it required the detention of foreign terrorist suspects, but it didn't require the detention of domestic terrorist suspects. And there was simply no rational basis for distinguishing. I mean, a person's nationality doesn't make him more or less dangerous. If somebody's a suspected terrorist, he's a suspected terrorist. Whether he was, born in this country and has a UK passport or not. So that was a straightforward rationality decision. The child benefit case was a much more, a judgment of a different kind altogether. Now, I'm not sure if I've answered all your question. I think I've forgotten part of it.
If I could just add one bit to Lord Faulkner. The idea that there won't be more declarations of incompatibility, I think, is unlikely to eventuate, because if the government's proposals are to encourage the courts to take a less muscular reinterpretation of parliamentary language in order to make them comply with the Convention on Human Rights in the interests of legal certainty, the consequence may well be that there will be more declarations of incompatibility, and that may be something that Parliament would welcome, rather than having a particularly reinterpretative function in the Human Rights Act. So I suspect that if that goes through, there will be more declarations. in the future.
If I could also just say...
Can I just interject for a moment? Belmarsh was not a declaration of incompatibility case, was it? It was an order.
It was a declaration. There's an application for a declaration of incompatibility. It was primary legislation that we're dealing with. It is a declaration of incompatibility case.
Not in Belmarsh, I don't think.
It is.
No, we'll have to look it up again. But that's my
we can check that later.
Can I just have
a vote? I don't think we can vote on that one.
Can I just add? I mentioned in my I mentioned some time ago that we'd also decided. I gave it as just an example. I mean, obviously, the government is still losing cases in front of us. It doesn't win all its cases. I gave examples over the past year of 2 cases where we had to remind the Home Secretary that court orders are to be obeyed. And you have to behave lawfully. And the idea that we have gone soft, as it were, on the government, or we are reluctant to find against the government, is completely without foundation. What has been perhaps more evident in our judgments is greater respect for the separation of powers. But that's a different issue.
Can I just ask one quick question on this? Do you see a distinction between public criticism of the decisions of the judiciary and criticisms of the justices personally? And if so, what impact does that have on or what implication does that have for how the Lord Chancellor discharges their duties in respect of the independence of the judiciary?
Well, I think there is a difference because it's one thing to say that you disagree with our decision. That's everybody's prerogative. It's another thing to attribute to us a lack of integrity in reaching it. And we saw that. I mean, this is why there was such a fuss over the Miller 1 in particular and the enemies of the people issue, where the allegation being made, and sort of the same thing with Miller 2, the allegation being made was the judges didn't decide this as a legal question. They're determined to stymie the will of the people that we should leave the EU. And so what's actually going on here is the judges giving effect to their political beliefs and not their understanding of the law. Now, that's it's obviously a very serious allegation to make. Insofar as people believe it, it has very serious implications. And that's why the judges, looked to the then Lord Chancellor to defend them over the Miller 1 decision in a way in which which we wouldn't dream of doing if all that's happening is that people are expressing dismay or disagreement with a legal decision that we've made.
May I add how strongly I agree with Lord Reid on that matter? I was invited recently to attend and respond to a lecture on judicial independence, which was given in the think tank policy exchange by a professor. And he came up with the suggestion that the judges were wrong to rely on the Lord Chancellor, which he described as the saviour Lord Chancellor theory, to speak out when judges are unfairly criticised for their judgments in the media and elsewhere. And I hope I gave an adequate response to that. I mean, judges can't enter the fray to respond to criticism, and therefore it's because of that it's very important that the Lord Chancellor speaks out if there are unfair criticisms as to the motivation of judges, to maintain civility in public debate, and also, perhaps more importantly, to prevent the public from accepting an incorrect narrative of what has occurred, because that could damage the rule of law. Thank you.
Thank you. No, you had a quick follow-up?
No.
Okay, fine, thank you. Hong Kong, if we could turn to Hong Kong now. Lord Thomas, you had a question.
Yes, I've been interested in the reaction to your resignations. Yes. Carrie Lam said that foreign judges were only asked to swear to uphold the basic law, bear allegiance to Hong Kong and serve its people. I quote, "We've never said or required them to support the executive branch or endorse its policies and measures." The news was met with widespread dismay. The Hong Kong Bar Association, the Law Society of Hong Kong, expressed deep regret. Senior Counsel and Executive Council member Ronnie Tung wished the pair had shown more backbone to resist pressure from politicians, and former Chief Executive C.Y. Leung, meanwhile, did not hold back, calling the judge's departure a permanent stain on Britain's judicial independence. So that's a fairly strong reaction. I'd be interested in your comments upon it.
Well, can I say first it was a matter of deep regret to me as well, that we felt we had to resign. In answer to the first point you raised about the scope, as it were, of our responsibilities, when the national security law came into force in the summer of 2020, I discussed the way forward with the Lord Chancellor and the Foreign Secretary. All three were involved because our participation in Hong Kong was to implement an agreement that the government, particularly the Lord Chancellor, entered into in 1997, and which Lord Faulkner renewed in 2004, under which Britain undertook to provide judges to the Court of Final Appeal in Hong Kong. And the operation of the agreement obviously depended on two things. One was the government's continued willingness to operate it, and secondly, the Supreme Court's continued willingness to provide judges to serve under it. And since effectively either side, the government or the judiciary, could pull the rug on it, I and the two ministers thought that the best way forward was for us to jointly monitor what was going on in Hong Kong and have discussions of the implications periodically to decide where we stood. And we also agreed on criteria that we wanted to have in mind in monitoring what was developing. And it was actually me who suggested, or insisted, that we have a criterion which wasn't to do with the courts, but was to do with society more generally. Because I felt that if, for example, to take an example, the courts in South Africa continued perfectly to apply the rule of law during the apartheid era. But I wouldn't have wanted any Supreme Court justice to have been serving on the courts there in that period, because the society was one in which our judges would just bring discredit on themselves if they manned one of the major institutions of government in that society. And I thought the same was well, we should at least guard against that possibility in relation to Hong Kong as well. And so what happened thereafter was we received briefings prepared by the Foreign Office on what was happening, and we assessed what was going on against the criteria and formed a judgment as to whether we should carry on working there or not. And there was, as everybody knows, there's been a gradual erosion in political freedom and consequently in freedom of speech in Hong Kong, which became progressively and noticeably, I felt, worse in the latter part of last year and the early part of this year. The courts themselves were continuing to operate in accordance with rule of law values, although they were under pressure. And it has to be said that one can't completely divorce what was going on in the courts from what was going on outside the courts, because essentially what was going on outside the courts had two components. One was the use of powers conferred by the national security law to close down businesses and seize property. The other was the arrest of people on charges of having violated either the national security law or laws passed during the period of British rule, concerned with sedition, for example. And once they were arrested, they were then being refused bail, essentially because of the gravity of the charge. But the consequence of, is that, for example, if you were a shopkeeper who had posted on social media your criticism of the absence of a vaccination program in Hong Kong, for example, then you would find yourself arrested on a charge of sedition, refused bail, and you're then liable to be detained in prison for the best part of a year, perhaps, before you come to trial. So, in the light of the crackdown on freedoms to which we, on the Supreme Court, and indeed in our society, are committed, that a stage was reached when we were in agreement that the time had come for us to withdraw. Now, we were not, I was not under pressure from politicians. That's a mistaken reading. There were some things published in Hong Kong which may have encouraged that misunderstanding. But I actually sought the meeting at which we took a decision because of my own concerns, and found that ministers were of the same view. Oh yes, and so the final point you mentioned was judicial independence. Well, there was no compromise of our judicial independence. It would have been rich irony if there had been, but there was none. The discussions I had with ministers arrived at a consensus, and I wasn't being dragged out of Hong Kong, as it were. I felt the time had come when we had to call it a day in the interests of the values that we represent. I have to say, it's a matter of great regret. I was very fond of Hong Kong. The people were unfailingly friendly and courteous. I have the highest regard for my former colleagues on the Court of Final Appeal, and I'm very saddened that matters ended this way, but there it is.
So you're very clear that it was your decision and not any political influence either from this government or from the Hong Kong government which led to your resignation.
That's right. In the government having reached the same view, that they thought it was time for the government to withdraw from the agreement, that would, in any event, have compelled us to resign, because we could hardly go on sitting in China on a Chinese court if when the taxpayer is paying our salary. If the government had wanted to withdraw from if the government wanted to withdraw from the agreement, But as I say, the continuation of the arrangement required the agreement of both the government and the court and me as the head of the Supreme Court. And we both took the view that the time had come to call an end to it.
Does the continuing presence of 6 former Supreme Court justices and justices from Canada and from Australia, does that cause you concern?
No, it doesn't. I think it's a matter for them. They are retired. They have to make their own decision. They're not in the same position, I think, as a serving judge exercising public power in the UK.
I take it you're not aware of any pressure from the Hong Kong government on them to stay?
No, certainly not. I have, in fact, been in discussion with them, and I'm sure it would have been mentioned. So, no.
Thank you very much. Thank you.
Can I ask,
yes,
if you hadn't been paid by public servants, if you are not chairman and deputy chairman of the Supreme Court, then the situation would have been different?
Well, we'd have been in the same boat as just say I'd retired, for example, I'd have been in the same boat as those who have retired.
That's the break point for you. The break point was that you were serving on the Supreme Court at the moment, not the principle of collaborating with the Chinese regime in Hong Kong.
I personally would have felt the time had come to leave, in any event. Even if I had retired, I would have felt the time had come. But because I am the President of the Supreme Court, my primary concern had to be the reputation of the Supreme Court and behaving, and that institution behaving as it ought to in our Constitution. And so whatever my own views happened to coincide, but I'd formed a view that it was no longer in the interests of the Supreme Court. In fact, it was damaging to the interests of the Supreme Court and the respect in which it's held for us to continue.
And if the other 6 seek your advice, what would you say?
Well, I would say to them it's a matter for them. I wouldn't. I mean, we're talking about extremely experienced, very, very experienced judges. I mean, two of my predecessors, the Chief Justice, the former Chief Justice of Canada, for whom I have the utmost respect, and two former Chief Justices of Australia, and another very senior Australian judge whom I also have great respect. So and former colleagues on the Supreme Court. Those who weren't president were members of the court and were colleagues and remain friends. I don't think they need my advice, but it's their choice what to do.
If I could just add, if I may, I also tendered my resignation at this time, and I think it is of central importance that Robert and I were members of the UK Supreme Court with public duties in this country. There have been 2 sides to this debate throughout, and the matter has been finely balanced for quite a long time. I mean, clearly, the concerns about the removal of people's freedoms in Hong Kong has been weighing very heavily on Robert and me, and no doubt our colleagues who've remained. But the other side of the coin is an equally real concern that we should do what we could in difficult circumstances to support the people of Hong Kong and support the able judges who are trying to uphold the rule of law in the way that we've traditionally understood it in this country, and they continue to understand it that way. So I think it's a very finely balanced decision, and I certainly wouldn't treat my resignation as any implicit or explicit criticism of those who've reached a different view.
Yes. Well, a couple of supplementaries. Lord Howell and Lord Faulkner. Do you want to come in, Lord Howell? Lord Faulkner.
I've got particular views on this. I don't want to, I mean, you know what they are.
I do.
And I completely accept that you, as the two office holders, are in a different position from the ex-members of the Supreme Court, and it is their decision. You, Lord Reid, said in his statement, "I have concluded in agreement with the government that the judges of the Supreme Court cannot continue to sit in Hong Kong without appearing to endorse an administration which has departed from values of political freedom and freedom of expression to which the justices of the Supreme Court are deeply committed," with which I agree, that statement. Presumably the 6 former justices of the UK Supreme Court are equally committed to those values.
Yes.
And without in any way being critical of them, it must be better for the UK. And it is their decision in a way that's different from you two. They should resign on the basis that they would be sending the message that the justices of the Supreme Court, past and present, are deeply committed to those values.
Well, it isn't for me to speak on their behalf.
No.
You should understand that they have served on the court in Hong Kong far longer than Patrick or I. Lord Hoffman, for example, has served on it since the 1997 withdrawal. What's that? 25 years. And some of the others for not much less than that. There are very strong personal ties of friendship to the judges there. I think Lord Thomas mentioned that the perception in Hong Kong that our withdrawal is a betrayal, and that if you like, we were the canaries in the coal mine, we've disappeared at the first whiff of gas, and we haven't stayed there to help them out, and they may be more vulnerable as a result of our leaving. All of that is true, and I think our colleagues, out of our colleagues' feelings of loyalty to their colleagues on the Hong Kong court and to the people of Hong Kong, are probably a weighty factor in their thinking.
Questions? Well, I think we've come to the end of all our questions, and thank you very much. Indeed, it's quite a long session that we've had today. Thank you very much for sharing your thoughts. We very much enjoyed the discussion, and you've given us a lot of food for thought. Certainly, I've taken a lot of food for thought from it. And thank you very much for joining us today, and thank you very much indeed.